Professional responsibility. Attorney-client relationship arises upon express or implied agreement or by court appointment. The client's belief is determinative. Ethical duties generally. An attorney owes their clients the duties of competence, confidentiality, loyalty, and financial responsibility. An attorney owes to third parties, opposing counsel, and the court the duties of candor, dignity to the profession, and fairness. Competence. An attorney shall represent a client with legal knowledge, skill, thoroughness, and preparation reasonably necessary. California, an attorney shall not intentionally, recklessly, or repeatedly fail to competently perform legal services. Lacking legal knowledge and skill. An attorney who lacks the legal knowledge and skill reasonably required to adequately represent their client may associate or professionally consult with a competent attorney in the area of law, acquire the necessary legal knowledge and skill required for competent representation, or refer the client to a competent attorney. Communication. An attorney shall promptly communicate with their client with respect to informed consent, status of the matter, comply with reasonable client inquiries, and about any limitation to non-permitted representation issues. Diligence. An attorney shall act with reasonable diligence and promptness in representation, and, unless representation is properly terminated, the attorney must pursue the matter to the end. Confidentiality, ABA. An attorney shall not reveal information in representation unless client gives informed express consent, there is implied authority, or as permitted by law. Attorney may reveal information in representation to the extent necessary to prevent reasonably certain death or substantial bodily harm, prevent a crime or fraud resulting in substantial financial injury of another. California. An attorney shall make reasonable good faith effort to dissuade client and inform client of attorney's ability to reveal as much information as necessary to prevent such crime. California does not recognize exception for financial injury. Loyalty. An attorney shall avoid conflicts of interest adversely affecting their client. Potential conflicts may occur between a current client and another, a former client, or an attorney's personal interests. Current client and another. Representation materially limits loyalty to another client, former client, a third person, or by a personal interest of the attorney. Former client. An attorney shall not represent a party where their interests are materially adverse to the interests of a former client in the same or substantially related matter without informed written consent. Between a client and attorney's personal interest. Unless an attorney reasonably believes that they will be able to provide competent and diligent representation, an attorney shall not represent a client whose position is adverse to their personal or professional interests. Business transactions with clients. An attorney shall not enter into a business relationship with a client unless terms are fair, fully disclosed in writing, client is advised to seek independent counsel, and client gives informed written consent. Exception to conflicts, two or more clients may be adverse to each other. If an attorney reasonably believes that they can provide competent representation, not prohibited by law, clients are not asserting claims against each other, and clients provide informed written consent, an attorney may represent the parties. California requires written disclosure of the conflict as well. Sexual relations with clients, ABA and California are the same now, shall not, unless relationship existed prior to representation, and relationship must not become a conflict adverse to the client. Financial responsibility. An attorney shall represent their clients in a fair and fiscally responsible manner. This includes representation agreement, fees, scope of representation, contingency rules, and safeguarding client documents and property, among others. Representation agreement. Agreement shall fully disclose how all fees, costs, and expenses are calculated and the scope of representation. Writing requirement. ABA and California generally. An attorney shall not make an agreement for, charge, or collect an unreasonable, illegal, or unconscionable fee. ABA, no writing required for regular fees. California, all fees over $1,000 need to be in writing unless client is a corporation, agreement was made during an emergency, client waives the requirement in writing, or for a previous client for similar services. Scope of representation. The client decides objectives of representation to settle a matter, and in a criminal case as to a plea to be entered, waive jury trial, and to testify. what to do. The attorney consults with their client as to the means by which the objectives are to be met, how to do it. Contingency fees. Fees must be in writing, signed by the client, stating method by which the fee is determined, including percentages in event of settlement, trial, or appeal. State expenses deducted from recovery and whether such expenses will be deducted before or after contingency fee is calculated. California requires attorney to sign as well, and each receives a copy. Same as for over $1,000 above. California, fee is negotiable unless a negligence claim against a healthcare provider, in which special math is involved. Criminal or domestic contingency rules, never allowed for criminal cases. ABA may not enter into contingent agreement for either type of case. California, domestic is allowed if it does not promote divorce. Referral fees between attorneys. ABA, attorneys can share referral fees with other attorneys so long as the referral is to a competent attorney, client agrees in writing, and the fee is reasonable. California requires a client must consent in writing after being given a full explanation of the referral. Referral generally. An attorney shall not give anything of value to a person for recommending the attorney's services. However, a nominal gift of appreciation may be allowed. Proprietary interest in the cause of action or subject matter. Shall not acquire unless for a lien to secure fees or to contract for reasonable contingency fees. Solicitation of gifts. ABA shall not solicit or prepare an instrument that gives the attorney a substantial gift unless the attorney is related to the client. California shall not induce a client to make a substantial gift or prepare an instrument which does, unless related. May accept a gift if it is fair and with no undue influence. Permissive withdrawal, allowed for any good and valid cause so long as it can be accomplished without material adverse effect on the interests of the client. Unreasonably difficult client, attorney finds client's actions are repugnant. Mandatory withdrawal, with authorization of the court if the representation will result in violation of rules of professional conduct or law. The attorney's physical or mental capacity substantially impairs ability to competently represent the client, or the client discharges the attorney. Termination withdrawal. Upon termination or withdrawal for any reason, an attorney shall promptly release all client materials, property, and any undisputed funds. Safeguard property. An attorney shall reasonably protect client property, keeping it separate, promptly return property, and disperse undisputed funds to the client. Fee dispute. Pay any undisputed funds promptly while holding back disputed amount. Duties to other than clients. An attorney owes duties of candor and fairness to third parties, opposing counsel, and the court. Candor. An attorney has a general duty of candor to third parties, opposing counsel, and the court. An attorney must not allow the court to be misled by false statements or evidence which the attorney knows to be false. Abuse of discovery. An attorney must not make a frivolous discovery request or fail to make reasonable efforts to comply with proper discovery requests. ABA only. Meritorious claims. An attorney shall not bring or continue a claim or conduct a defense lacking merit. An attorney shall not pursue frivolous actions. Dignity to the profession of law. An attorney shall not engage in conduct disruptive to the profession of law. Fairness. An attorney has a general duty of fairness to third parties, opposing counsel, and the court. Threat of actions. An attorney shall not threaten to present criminal, administrative, or disciplinary charges to obtain an advantage in a civil dispute. Employment of disbarred, ineligible attorney. An attorney may employ an ineligible attorney to perform research, drafting, and clerical duties which do not constitute the practice of law, with written notice given to the State Bar of employment, a full description of the person's current bar status, list the activities not allowed by the bar, and that the party will not perform such activities. California Rules of Professional Conduct 5.3.1. Basically, if a disbarred attorney is going to work for us in litigation support, we have to tell the bar in writing, repeat the duties that they cannot participate in, and promise that they will not. Attorney shall provide written notice to all affected clients. Attorney shall retain such data for 2 years following termination of employment with such clients. Represented parties. An attorney shall not communicate with parties known to be represented by counsel in the matter without consent or court order. Responsibilities of supervising, supervised attorneys. An attorney has the duty to supervise attorneys and staff to ensure that they do not violate ethical standards. Also, an attorney being supervised is responsible for clearly unethical misconduct even if following orders, which lack a reasonable resolution of an arguable question of professional duty. Attorney as a witness. An attorney shall not advocate in a trial in which the attorney is likely to be a witness unless the attorney's testimony relates to an uncontested matter, relates to the nature and value of legal services rendered in the matter, or the attorney has informed written consent from the client. Responsibilities of a subordinate attorney. An attorney does not violate ethical rules if they act in accordance with a supervisor attorney's reasonable resolution of an arguable question of professional duty. Reporting professional misconduct, ABA. An attorney must report another attorney or judge when the attorney knows the attorney, judge, violated ethical rules that raise a substantial question as to their honesty, trustworthiness, or fitness as an attorney, judge. California, an attorney is not required to report known violations. However, an attorney must self-report for a variety of infractions. Prosecutors must have probable cause to proceed with a case, must disclose any exculpatory evidence, must promptly disclose new exculpatory, credible, and material evidence, must not allow for extrajudicial statements to be made to the press.